Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. On June 4th, the Supreme Court decided Sripetch versus Securities and Exchange Commission, case number 5-466, 9-0.
Justice Gorsuch wrote for a unanimous court. The ruling, the SEC need not prove investors actually lost money before forcing a securities fraudster to surrender his profits. Justice Thomas filed a concurring opinion agreeing with the outcome but dropping a warning about jury trials that defense lawyers across the country read immediately. If you follow the markets, invest for retirement, or work anywhere near financial services, the decision affects you.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report, and if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, let's proceed. And as you may recall from our preview episode, we walked through the key arguments before oral argument on April 20th. Today, the court drew the lines.
Remind me, who is Onkaruk Sripetch?
A Los Angeles resident who turned the low-rent corner of the stock market into a $6.6 million operation. Penny stocks, ultra-cheap shares of tiny companies nobody follows. He and his associates bought shares of at least 20 of those companies, flooded the internet with fake promotional hype, watched the price spike, and immediately sold before everything collapsed.
Pump and dump.
Textbook. They never disclosed they funded the promotions, never revealed they planned to sell, and on top of that, they ran something called match trading. Coordinated fake transactions across separate accounts designed to make these stocks look like they attracted real buyers. Through all of it, $6.6 million in illicit profits.
And the government showed up.
Twice. First, the criminal case, Sripetch pleaded guilty to selling unregistered securities and collected 21 months in prison. At sentencing, he used his own words. His conduct produced actual impact on the lives of real people who invested their money in empty companies. He said investors suffered financial troubles.
He confessed to real harm, in court, under oath.
And then in the civil case, where the SEC sought over $4.1 million in disgorgement, his lawyers took a completely different position. Disgorgement, by the way, means forcing a wrongdoer to hand over profits from illegal conduct. Sripetch's team argued the SEC never proved any specific investor lost any specific dollar. No documented financial loss, no disgorgement.
Can those two things actually come apart?
Easily. Run a pump and dump where the investors who bought during the hype sold before the price crashed. They might not lose a single dollar. The fraudster still pocketed millions. So the question becomes, does the fraudster keep the money because his victims got lucky?
The district court in San Diego, the Southern District of California, ordered Sripetch to pay $2,251,923.16 in disgorgement, plus another $1,051,353.77 in prejudgment interest, over $3.3 million total. He appealed. The Ninth Circuit, California, and the West Coast affirmed and went further, ruling that proving pecuniary harm to investors operates as no precondition to disgorgement whatsoever. But the Second Circuit, New York, the financial hub, ruled the opposite in a 2023 case called SEC versus Govil, requiring proof of actual investor losses. Two of the country's most powerful circuit courts, opposite results, identical legal question. The Supreme Court took the case on January 9th, 2026, to settle it, argued April 20th, decided today.
So what did the court actually answer?
Whether the SEC must prove that investors suffered pecuniary harm, actual documented money loss, before a federal court orders disgorgement. Plain English, can the government strip a fraudster's profits even when no victim can prove losing a dollar?
And the answer?
Yes, the government can. Here's why. Justice Gorsuch opened by drawing a line most people blur, damages versus disgorgement. These two remedies work completely differently. Damages at law look at the victim's loss. A court calculates what the plaintiff lost and orders that amount paid. The entire goal, put the victim back where they started.
Make the victim whole. Disgorgement, an equitable remedy, meaning one rooted in the old court tradition of achieving fairness, looks at a different number entirely. Not what the victim lost, what the defendant gained by invading the victim's legally protected rights. That amount gets stripped away.
Two totally different measuring sticks.
And that distinction resolves the case. Traditional equitable principles, centuries of them, never required a showing of financial loss before a victim could claim the wrongdoer's profits. The restatement of restitution, a major legal encyclopedia courts, treat as authoritative, confirmed it plainly. When a person suffered an interference with protected interests, courts may award restitution of the defendant's wrongful gain even when the plaintiff suffered, quote, no measurable loss whatsoever.
And at oral argument, Justice Jackson pressed Sripetch's lawyer directly on exactly this point: unjust enrichment, the ancient equitable idea that courts step in when someone profits wrongly at another's expense. She kept asking, why doesn't that concept just resolve this case? Geyser, arguing for Sripetch, never fully answered her.
The majority grounded everything in 4 historical cases. First, Raven Red Ash Coal versus Ball, a 1946 Virginia Supreme Court case. A company held a railroad easement to haul coal from one specific tract. Without authorization, it used that same railroad to haul coal from other tracts. The landowner admitted suffering, essentially, no more damage, than occasional exclusion from his own land. The court still awarded the landowner $500, the fair value of the benefit the company unjustly extracted.
Zero financial loss. Still got the defendant's profits. Then Corey versus Struve, 1915 California. Defendants sold beet tops for cattle feed instead of plowing them under as their lease required. Both parties agreed. The plaintiff suffered zero pecuniary loss from the deviation. The court still ordered the defendants to turn over the sale proceeds. Edwards versus Lees, 1936 Kentucky. A man opened a tourist cave. About a third of the cave sat under his neighbor's land. The neighbor couldn't access the cave from his own property and suffered nothing financially. The court still awarded 1/3 of the tourist profits to the neighbor. And Olwell versus Nye and Neeson, 1946 Washington. A company used someone's automatic egg washing machine without permission for years. The plaintiff had no use for it at the time and lost nothing. The court still ordered the company to disgorge its profits from the unauthorized use.
Every single case invaded legal rights, wrongdoer profited, victim collected the gain regardless of whether money actually left the victim's pocket.
That's the pattern across a century of cases in multiple states. And the principle makes intuitive sense. Think of it this way. If someone breaks into your basement and runs an illegal recording studio for 2 years, but you never once needed the basement, should they keep every dollar from those recordings? Your property rights invaded. Their profit came directly from that invasion. Equity says hand it over, full stop.
And Sripetch tried to argue Liu required pecuniary harm anyway.
He did. Liu versus SEC, that's the court's landmark 2020 decision, held that disgorgement must go for victims. Sripetch said victims by definition means people who lost money. The majority disagreed. Liu drew the for victims requirement from traditional equitable principles, and those principles define a victim as someone whose legally protected interests a wrongdoer invaded, not necessarily someone who lost dollars. Nobody disputed that Sripetch's investors suffered violations of their legally protected interests. Victims, full stop.
Justice Sotomayor wrote Liu. She grilled Geyser on this at argument, at one point essentially asking him why she bothered analyzing certain language in Liu if the principles he relied on governed independently of that language. He tried to finesse the answer. The majority gave the more direct one.
And on the restore the status quo argument, Sripetch said disgorgement aims to restore the status quo. So if nobody lost money, nothing needs restoring. The court flipped that around. When a defendant enriched himself without leaving the plaintiff financially worse off, 2 competing status quos exist. Either strip the wrongdoer of his unjust gain, or let him keep the profit because the victim's bank balance looks unchanged. Justice Cardozo said it well in an old New York case. Equity won't stand idle when inaction confirms the wrongdoer's purpose.
What about the bigger Section 78 UD 7 fight? Whether the 2021 congressional amendments freed the SEC from traditional equitable rules entirely.
The court ducked it entirely. The government and Sripetch both argued hard about whether Congress's 2021 amendments changed the fundamental character of disgorgement, including whether the SEC could keep disgorged funds in the Treasury rather than routing them to investors. Justice Gorsuch at argument floated the exit route himself, asking the government's lawyer, Deputy Solicitor General Malcolm Stewart, whether the court even needed to resolve the distribution question to answer the pecuniary harm question. Stewart said no, the court took that exit, assumed without deciding that disgorgement still functions as an equitable remedy, answered only what the question presented asked.
Clean and narrow.
9-0. Gorsuch for the court, Ninth Circuit affirmed. The SEC keeps its full toolkit.
Now, Justice Thomas wrote separately. Concurring, meaning he agreed with the result but wrote to plant a marker for the future. At oral argument, Thomas called disgorgement homeless to begin with. Courts invented it in the 1970s with no statutory authorization, treating it as an implied equitable power. His concurrence made that homelessness argument into a constitutional one.
What's the argument?
In the 2021 amendments, Congress set different limitations periods for disgorgement and for equitable remedies. Two separate categories, two separate deadlines. Thomas argued, if Congress treats them as different things, then disgorgement no longer functions as an equitable remedy. It now qualifies as a legal remedy. And under SEC versus Jarkisy, the court's 2024 decision about administrative courts and civil penalties, when the SEC seeks a legal remedy, the Seventh Amendment entitles the defendant to a jury trial.
So every SEC disgorgement action would go to a jury?
Under Thomas's view, yes. 12 jurors instead of a judge alone. Slower, more expensive, unpredictable. Thomas wrote for himself today. But he wrote loudly.
Gorsuch at argument flagged the same issue, telling Stewart that if the government wants the equitable remedy, it needs to follow equity's rules. If it doesn't distribute funds to investors, he suggested, the Seventh Amendment might attach. Stewart said the government disagreed. Gorsuch called that position pretty perilous.
Thomas just formalized the peril on the record.
All right. What this actually means. For the SEC, this preserves the entire enforcement model. The agency ordered over $6.1 billion in disgorgement in 2024 alone. Under Sripetch's rule, the SEC would have needed to track down individual victims, prove each one lost specific dollars, and calculate identifiable losses before collecting anything. Pump and dump schemes, the kind Sripetch ran, make that nearly impossible.
For fraudsters,
The nobody lost money defense no longer functions as a shield. Structure your scheme as cleverly as you want. Leave your investors technically unharmed on paper. Your profits still belong to the government.
and for regular investors,
Penny stock fraud hits retail investors hardest, people who chase cheap hype without sophisticated tracking of their losses. If the SEC can collect disgorgement without proving individual losses, it can pursue enforcement on behalf of whole communities of investors who could never successfully sue on their own. The money can still flow into an investor protection fund.
but two questions the court left open. First, can the government keep disgorged funds in the Treasury instead of distributing them to investors? The court explicitly declined to answer. At argument, Gorsuch cited the numbers directly. $6.1 billion ordered in 2024, $345 million returned to investors. That's roughly 6 cents on the dollar. If the SEC treats disgorgement as a revenue tool rather than a victim compensation mechanism, the equitable principles question and Thomas's jury trial question both resurface in a harder form.
Second, does the Seventh Amendment require a jury trial for disgorgement under the 2021 statute?
Thomas says yes in a future case. If 4 more justices agree, the SEC's entire enforcement model shifts. Every securities defense lawyer reading that concurrence today started strategizing their next case. The fuse Thomas lit today sits right beneath the foundation of how the agency operates.
Bottom line, the SEC won everything on the table. The fraudster loses. The big jury trial question stays open.
And the $6.1 billion enforcement machine keeps running.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
If today's episode saved you from a penny stock scheme, or at least explained why fraudsters can't hide behind their victims' good luck, leave us 5 stars. You owe us at least that much.
5 stars. Don't invest in anything called Hype Corp. Talk to you soon.